Parliament from the government and recognized opposition caucuses, as selected by their respective leaders. The members were Jacques Gourde, Carrie Lynn Findlay, and Greg Rickford of the Conservative Party of Canada, François Beauvois of the New Democrat Party, and the Honourable Stéphane Dion of the Liberal Party of Canada. The panel was tasked with assessing the candidates and providing an unranked list of 3 qualified candidates to the Prime Minister and myself for our consideration. To help ensure a full, balanced, and objective assessment of the candidates, the members of the panel met to review the resumes provided by each candidate, as well as a number of reported judgments and publications. The panel members also consulted with the Chief Justice of Canada, the Chief Justice of Quebec, the Attorney General of Quebec, Le Bureau de Quebec, and the Canadian Bar Association. The list of 3 candidates, which included our nominee, were unanimously approved by the panel. And before I introduce the nominee, I would like to address a few procedural issues that will govern today's proceedings. First, as was the case last year at the hearing for Justices Karat-Katsanis and Moldaver, we will begin with an opening statement from our constitutional expert, Maître Jean-Louis Baudouin. This will be followed by opening remarks from the nominee. There will be then 2 rounds of questioning by committee members consisting of up to 8 and 5 minutes respectively. As chair, I will be responsible for enforcing these time limits, and the proceeding will end with concluding comments by Maître Baudouin. Second, I would like to inform our members and guests that parliamentary privilege does not apply to these proceedings, as this is technically not a parliamentary committee. This means that protection from defamation does not apply as it would normally in parliamentary proceedings. I leave it to each of you to exercise your good judgment accordingly. Finally, I would like to remind you that our eminent member of the Canadian judiciary will be responding to our questions in a manner that reflects the independence and impartiality of our justice system. That means that some questions may not be answered fully or at all. Maître Baudouin will explain the appropriate scope of questions and the constraints on judicial speech for us shortly. I would ask that we, as committee members, respect those parameters within which our nominee is able to respond. Now, I have the honor and privilege of introducing an outstanding jurist as the government's nominee to the Supreme Court of Canada, Mr. Justice Richard Wagner of the Quebec Court of Appeal. Mr. Justice Wagner was born in Montreal on April 2, 1957. He studied at the Collège Jean de Brebeuf in Montreal. After graduating from the University of Ottawa with a bachelor's degree in political science and a license in law, he was called to the Bar of Quebec in 1980. He was a member of the Canadian Bar Association and a fellow with the Canadian College of Construction Lawyers. Justice Wagner is a former partner of the law firm of Laverie de Billy in Montreal. He was a recognized and respected civil and commercial litigator and acted in a number of important cases before the Supreme Court of Canada. He often appeared as legal counsel before the Superior Court and Quebec Court of Appeal. His commercial litigation practice focused on areas such as real estate, commercial litigation, and professional liability insurance. He was recognized as a certified mediator by the Bar of Quebec and the Superior Court. He is also an executive member of the Construction Law section of the Canadian Bar Association, Quebec Division, and an instructor of the Pleading and Representation Program, as well as the Civil Procedure Program at the École de Formation Professionnelle of the Bar of Quebec. He is an active member of the Bar of Montreal as an executive and committee member. Justice Wagner was elected bâtonnier of the Bar of Montreal in 2001. On September 24, 2004, he was appointed a judge of the Superior Court of Quebec. Following his appointment to the Superior Court, he received the Merit Award Ward from the Bar of Quebec for his contribution to the legal profession, and more particularly for the creation in 2002 of the Centre d'accès à l'information juridique. Finally, Justice Wagner was promoted to the Quebec Court of Appeal in February 2011. Ladies and gentlemen, colleagues, please join me in extending a warm welcome to our latest nominee. I would like to move now to the next step and introduce the Honorable Jean-Louis Baudouin. Maître Baudouin holds a law degree from McGill University, a state doctorate from the Paris Faculty of Law, and a graduate degree in comparative law from the Faculté Internationale de Droit Comparé in Madrid and Strasbourg. He's been a member of the Quebec Bar since 1959. Maître Baudouin was also a judge of the Quebec Court of Appeal from 1989 to 2009, and prior to that was a professor at the Université de Montréal's Faculty of Law, where he taught contract law, civil liability, medical law, and bioethics. He's now a senior counsel with the law firm of Pascan Martineau in Montreal. He's a prominent and well-known member of the Quebec Bar. Over the years, he's collected numerous honorary degrees, and more recently, in 2012, he was the recipient of the Grand Officer Medal from l'Ordre National du Québec. I will now ask the Honorable Jean-Louis Baudouin to provide us with an overview of the constitutional framework within which this hearing is to take place. Thank you, Maître Baudouin.
Minister, ladies and gentlemen, good afternoon. First of all, let me tell you how honored I am to appear before you today. For a jurist of mine age, it is indeed a great honor to participate, albeit modestly, in a process to appoint an individual to one of the highest and most respected positions in our country. It's also a pleasure for me to be here with Judge Richard Renaud, who I've known for many years, and whose career up until now has been extremely successful, as you can see from reading his curriculum vitae. Appointment to the Supreme Court of Canada is certainly an honor for him, but it's also a very heavy responsibility. Your role here today, because you are the last filter in a lengthy selection process to find the best candidate, is particularly important. Through your questioning, and I'd also like to say, through your dialogue with the nominee, you must verify this individual's professional and personal qualifications and, in general terms, his ability to fulfill his mission. The selection process that we undertake today is recent. It was used for the first time in 2006 when Justice Rothstein was appointed. It was again used in the fall of 2011 when Justices Moldaver and Karakatsanis were appointed to the Supreme Court. Some have expressed concerns and doubts about the process. Some worried that the process would lead to some abuse, to a politicization, and I'm using this word in its pejorative sense. Some were concerned that this whole exercise would be politicized, as we've often seen south of the border, when nominees to the U.S. Supreme Court go through the process. We've seen nominees being put in very embarrassing situations, almost as if they were undergoing a cross-examination. However, when you look at the transcripts for 2006 and 2011, we can see that there is no basis for this concern, and this is good. Your predecessors, in both cases, demonstrated great wisdom, reserve, and they realized that this was not about putting a person or ideas on trial, but rather a way to verify through a cordial and calm dialogue the person's aptitude to fulfill this task. And I think that we have to really congratulate your predecessors for having understood this philosophy. Now, a very quick word about the Supreme Court. The 9 justices on the Supreme Court are appointed by the Governor General on the advice of the Prime Minister. The Supreme Court is the highest court of the land, and it has an important and decisive role to play in the social and political directions of the country. Let me explain. You as parliamentarians have the responsibility, a very heavy one, to adopt legislation to set the direction of the country in various sectors, be it legal, social, economic, etc. However, a legislative system can never, as good as it may be perfect and complete. At times, legislation has to be interpreted and their deficiencies have to be compensated for. And we also have to deal with inaccuracies. That's one of the roles of the Supreme Court. It's often contradictory jurisprudence from provincial courts of appeal that lead the court to establish the rule of the law for the entire country. In addition, with the arrival of the Canadian Charter, the impact of the Supreme Court on the life of the country has changed, and profoundly so. The court is indeed the last bastion for public and individual freedoms, the last defender of human rights, and the body which decides on the interpretation of the Charter. In a democracy such as ours, this mission is particularly delicate. The court, in fact, in the absence of accurate or precise legislation, has to fill the void and come up with solutions to some very complex issues that cause those going to court to experience various problems. The court only hears about 100 appeals per year, and they come from all jurisdictions of the country. So the cases that they do here are extremely important. That is why the personal and professional qualifications of the candidates have to be so important. What are they? Well, the first skill is that of being a good legal expert. But it seems to me that the selection process ensures that right from the start that this is going to be dealt with. All of the problems of all of the issues that the Supreme Court has to deal with are complicated and therefore require an in-depth knowledge of the law and special skills when it comes to discussing and resolving problems. The second qualification is open-mindedness. The justice, and I'm basing myself on my experience as having served on the Quebec Court of Appeal for 20 years, the judge has to be very open-minded, and that means three things. First of all, the individual has to be able to set aside certain of his or her moral or philosophical convictions and deal with issues in an impartial basis according to the law of the land. Also, the individual has to set aside any prejudice. The individual must challenge his or her own convictions and be able to change opinions or ideas without necessarily doing so in a negative fashion. And finally, the individual must preserve at all costs his or her independence. I sincerely believe that we have one of the best, if not the best, judicial system in the world. We have proven that this is the case up until now, and we must continue to do this in the future. This is so important for a democracy such as ours, and our judicial system has to develop to the benefit of all citizens. It is obvious that certain opinions that a Supreme Court justice will have to make are not necessarily going to be approved unanimously and can lead to controversy. The justice must, however, remain serene and above the mêlée. He or she must continue to render decisions in an impartial manner, regardless of the impact of the opinion and without feeling obliged to please private or public interests or even the government. To be a judge means that you're not out to win a popularity contest. Finally, from the strictly professional point of view, the individual has to be a team player. He or she has to be able to discuss matters freely with colleagues and to be open to others' opinions and to write in a very clear and precise manner. I can tell you that this is a hard job to do. That being said, what's your role here this afternoon, and what type of questions should you or can you ask the individual? Once again, the purpose of this exercise is not to delve into the nominee's current problems or past problems, but to ensure that the nominee, through his answers, has the personal and professional skills to fulfill this position. As your colleagues did previously, I think that we have to avoid questioning the nominee about
bien fondé de décisions qu'il aurait rendues par le passé, ou enfin sur des affaires qui relèvent davantage de sa philosophie personnelle à propos de controverses sociales ou politiques. Par contre, votre tâche, encore une fois, est bel et bien de vous assurer que le candidat répond au profil qui est exigé de cette importante fonction. Vous pouvez donc l'interroger en toute liberté sur la façon dont il conçoit son rôle, sur ce qu'il espère apporter comme contribution au développement du droit, ou plus généralement sur ses aptitudes à remplir ses fonctions, de même que sur sa motivation générale. Je termine ici, Monsieur le Président et Monsieur le Ministre de la Justice, pour ne pas empiéter sur un temps précieux, et je vous remercie de votre attention.
Maître Baudin, merci beaucoup. Maintenant, encore une fois, bienvenue. Justice Wagner, the floor is yours.
Thank you, Mr. Minister. Thank you for your kind introductory remarks. Monsieur le Ministre, distingués membres du Parlement.
Minister and members of Parliament, you will understand that I'm very pleased to be able to participate in this exchange as part of this nomination process for the Supreme Court of Canada. It's a pleasure to meet with you and to exchange ideas and to relieve any fears that you may have. Some of you may have had an opportunity to participate in a similar process when Justices Karakatsanis and Moldaver and Rothstein were nominated, and maybe you were doing this for the second or third time. For others, this will be a new experience. For me, this is a first and last experience.
Ne dit-on pas que l'on n'a qu'une seule chance de faire une bonne...
We have only one opportunity to make a good impression.
The elected representatives of the citizens of this country, I will do my utmost this afternoon to speak about myself so that you might fully acquit your role in this appointment process. I shall be most pleased to answer any questions you might have to the best of my ability. I understand that the task you are charged with is especially important in allowing Canadians whose daily lives are touched constantly by the decisions of the Supreme Court of Canada to learn about the persons nominated to our country's highest court. Je suis un Montréalais d'origine et je suis fier de mon héritage.
I'm from Montreal, and I'm very proud of my Francophone heritage and of my maternal language, my mother tongue, which is supposed to be one of the most beautiful languages in the world. I've always lived in Quebec, and I've always tried to do justice to my citizens when I perform my duties. This was a lifelong engagement which will be carried forward in the future. I must confess that I've been very blessed. I have two children, Charles and Catherine, who having seen the difficulties in practicing law, have decided to follow in their father and grandfather's footsteps. Charles is now 26 years old. He works for Heenan and Blanky law firm, and Catherine, who is 3 years older, is also a legal expert. She has a civil and common law degree, and she is now helping train lawyers. I'm very pleased to underscore that Catherine, last April, had a daughter named Juliette, named after her maternal grandmother. And she has been delighted with this little girl ever since then. I think that being a grandfather is something that I wear very well. And I didn't have to go through a selection process in order to enjoy this new role. I'm very proud of being a grandfather, and I hope that my granddaughter will be there to see my first gray hairs. Supreme Court nominees have to talk about themselves, of course. So we'll try not to be too hard on myself and not to be too complacent either. As as has been said, my story is that of a happy man. I grew up in with a privileged background. My parents didn't have great financial means, but we never missed anything. But I did have love and attention from my parents. My parents died at an early age, so you will not be surprised, therefore, that I talk about them today. My father, Claude Wagner, who died at the age of 55, or spent his time serving the public. His spirit, his generosity, and his sense of justice are a source of inspiration that I try to live on a daily basis. My mother, like other women of her day and age, was the person who was responsible for the family life, discipline, family life, and she also supported my father in his professional life. So I had a very traditional childhood in a very matriarchal society based on the respect of others. I've always been curious by nature. I was interested in studies. I grew up with my sister Joanne, who is 2 years older, and my brother Christian, who is 3 years younger. So I was the middle child. And middle children quickly learn how to compromise. And that enabled me to learn how to achieve consensus at a very early age.
From my youngest days, the bonds between us were necessarily close, especially given my father's busy role in public life. Family became, for me, the ultimate place of refuge, where each of us could find, in his or her own way, comfort, strength, and personal growth, while moving forward exciting yet turbulent times with happiness and serenity. My first contact with the judicial system goes back to when I was 7 years old. But please don't worry. It was not to appear before juvenile court. It was at that age that for the first time I walked into a building known at that time as the new courthouse in Montreal, the Ernest Cormier building. A place I will rediscover 47 years later as a judge of the Court of Appeal. J'ai fréquenté l'école primaire chez les Sœurs de la Providence pour entreprendre par la suite mon...
I attended elementary school, then I took classical studies at Jean Brébeuf College. I remained there for many years. I have a very good impression of the Brébeuf College. I was in a very stimulating school environment, and it really instilled a lot of curiosity. And I was able to participate in many sports activities. After my college studies at the age of 18, I left the family nest and I studied social science with a concentration in political science at the University of Ottawa. It was moreover here that I won my first legal battle, if you could call it that. Eager to begin my law studies, but while at the same time doing a BA in political science, I tried in vain to register at the law faculty. The registrar told me that the university rules did not enable a student to register in several faculties at once. Regardless of that, I challenged the rules, and I really did a lot of research, but I was told that that in fact there wasn't an actual law. So I was in fact able to pursue these studies, and the Senate had to change the rules that allowed students to enroll in more than one faculty. So that's enabled me to live here in the Outaouais region, and I worked here as a summer student, and I continued my studies. I have a very good memory of my days here in Ottawa. Once my studies were completed, I did an internship at the Laverie law firm, where I practiced law until I was appointed to the judiciary. I wanted to become a litigation lawyer, and I got my wish. I worked in this field for more than 27 years. I did this enthusiastically, and I did this enthusiastically until I was appointed to the Superior Court in 2004. I was able, as a result of my experience, to appear before many legal organizations. I had not yet completed my internship when I had the opportunity to plead before the provincial court, the Superior Court, and I even got to appear before the Quebec Court of Appeal. My associates told me that I was very meticulous and that I was taught to really respect the institution and clients. I met legal experts who were excellent: Vincent O'Donnell, Paul Carrier, and Jacques Chalbalneau. These two individuals were at the Superior Court and at the Quebec Court of Appel. As a student, I was able to rub shoulders with the very Honorable Jacques Fauteux, who is the former Chief Justice of the Supreme Court, who went back to legal practice in Montreal after his retirement. I've always enjoyed being an attorney, and I was also very pleased when I became Justice of the Supreme Court. In 1997, I had the opportunity to participate in the Collège Canadien de la Loi en Construction, and the assemblies or the general meetings were chaired by the Chief Justice Beverly McLaughlin.
To earn the confidence and loyalty of many clients, be they individuals or corporations, many of whom have not only honored me with their confidence, but also in certain cases with their friendship. Working in a large Montreal law firm had, of course, its share of advantages and unique experiences, but does not necessarily reflect the reality of the practice of law experienced by most lawyers. I then became interested in my professional order and its activities. My years of involvement with the Quebec and Montreal Bar Associations, as well as with the Canadian Bar Association, had an important impact on my view of things. It provided me with the superb opportunity to meet colleagues from various spheres of practice who, even though they were living different practical realities, contributed greatly to my education and understanding of the law. My happy experience in the affairs of the bar associations as counselor to the Montreal Bar encouraged me to present my candidacy for the position of first counselor and then as bâtonnier for the year 2001-2002. But before taking up the position of bâtonnier in 2001, I had to face a challenge with which you are more experienced than I, that is to run for office in an election. You see, it was the first time there was an election for the bâtonnier since 1956. I can honestly say it was an enriching experience, especially since I was elected with 91% of the votes. If only you could be so lucky. En tant que bâtonnier, et même si le barreau de Montréal était minoritaire.
As bâtonnier, and even though the barreau of Montréal was minority in the big barreau of Quebec, I got the support of a number of colleagues in creating a legal access centre, the CAGE, which since 2002 has provided all lawyers with quality access to legal information. This achievement is the fruit of substantial leadership based on transparency, open-mindedness, and a sense of compromise. This enabled us to fight for a common objective. The opinions were, of course, different, but I understood quickly that leadership is something that is earned and is not simply imposed. At the bar, I met many people from different horizons. My experience and my active practice before all courts encouraged me to share my knowledge with the students at the Bar College. I taught litigation techniques and civil procedure for a number of years. For the first time in several years, as bâtonnier, I put the tour of the bâtonnier back on the agenda. This enabled me to meet hundreds of lawyers in the greater Montreal region. The meetings were numerous, and they were tailored to the profiles and the practices of the attorneys that were invited. I informed them as to the big issues and answered their questions. This unique exercise gave me an opportunity to get closer to members of my bar and to better understand their needs, but also to inform them as to the issues of the day and tell them of the support that they had from the bar. I have memories that will forever remain with me of this.
We were all profoundly affected by the attack on World Trade Center in New York, a tragic event that has marked all of humanity. 3 weeks after the events, I was Montreal's representative at the first summit of the World Bar Associations, which brought together in New York City representatives of the local bar associations of 20 or so of the world's largest cities, including Paris, Madrid, Tokyo, New York, Beijing, amongst others. This summit, which took place not far from where the World Trade Center ruins were still smoldering, allowed lawyers from all continents to interact over the course of 3 days on the merits of our respective legal systems, as well as the issues we all faced, such as the breadth of legal aid and the workings and the appointment process of judges, access to the courts, and the inherent delays of judicial process. We had those discussions while reminded of the fragility of democracy and freedom as a result of the most recent events. À mon retour à Montréal,
on my return in Montreal, there were different feelings that I had after meeting representatives from foreign bar associations. Pride was one of those feelings, but also frustration and regret. Pride, because I realized to what extent our justice system compares favorably to just about any legal system worldwide, but also regret, because the undeniable qualities of our justice system in Canada are unfortunately not well known. So, since that time, as a lawyer and a judge, I took all opportunities in all forums offered to me to inform citizens, and especially young lawyers, about the merits of our justice system and also its shortcomings. Our justice system is a benchmark worldwide in terms of quality, time spent on cases, and independence. And this, however, should not mean that we rest on our laurels and be content with the status quo. We need to take all opportunities offered to us to improve the system. But this task is not the responsibility of one single group. It is up to all judges, lawyers, parliamentarians, government representatives to contribute to improving the system while preserving what has thus far been achieved. This time in New York also encouraged me to do something else, and that is to support the justice system. I believe that there is a fine line between respecting the rule of law and anarchy. The tragic events of the Middle East remind us on an almost daily basis of the shortcomings of the democratic societies across all spheres of society. It is crucial that we keep in the minds of our fellow citizens the credibility of the justice system, its integrity, its effectiveness, in order to make sure that cynicism is kept to a minimum, and so that there is not a parallel system, or worse still, disillusionment and the impression that the justice system is inaccessible. Judges need to do their share, but bar associations should also be involved. so too should governments, media as well. As the president of the Conference of Judges of the Superior Court of Quebec, I published a letter in November in which I reminded people that the sustainability of our democracy and the respect of its fundamental values, including the freedom of expression, was largely due to the impartiality of the judiciary, of its independence, and especially of its credibility among the legal community. I am a fervent advocate of the independence of courts. In this open letter, I stressed, and I quote, the judiciary is only accountable to the person subject to trial. It is independent and it must be subject to criticism, but it garners the support of all actors in civil society. Otherwise, it may, little by little, and in an insidious fashion, lose its independency and its capacity to render justice.
On September 24, 2004, I was appointed the judge of the Superior Court of Quebec. This appointment allowed me to realize a dream that I had been caressing since my years at the Faculty of Law, and that is to return to criminal law, an aspect of the law with which I had not had the occasion to familiarize myself, given my civil and commercial litigation practice. Upon my appointment to the court, I registered for and took all of the available training sessions in criminal law across the country. Soon enough, I joined a group of judges on the court who take on the solemn duty of presiding criminal jury trials. The challenge was great, but fully worthwhile. I enjoyed every moment that I spent in that role. The substantive law issues, the particular environment, and the unique relationship that exists between a judge and a jury were all elements that contributed to making my years in the criminal division truly interesting and exciting. Those years brought me an intimate familiarity with the leading decisions of the Supreme Court of Canada on matters of criminal law and of the Charter, and especially an understanding of the ever-changing contours of Charter jurisprudence, which, naturally enough, are not fixed in stone. Le 3 février 2011, j'ai accepté de relever un autre.
3rd of February 2011, I took up another major challenge when I joined the team of the Appeal Court of Quebec. I rubbed shoulders with excellent jurists, all very concerned with accomplishing their jobs carefully, with empathy and expertise. My experience at the Court of Appeal was very helpful to me and would be helpful to me if my nomination to the Supreme Court is confirmed. It helped me to draft decisions and learn more about the collegial approach, which requires of judges a certain level of suppleness of thinking and a level of compromise in finding solutions to differences. Madam, ladies and gentlemen, parliamentarians, it is therefore with great humility that I stand before you, or sit before you rather, today. My presence testifies to my commitment to the legal system, and first and foremost, my role is at the service of persons subject to trial. This is a noble and generous justice that I have subscribed to.
To be standing before you as the designate for the position of Justice of the Supreme Court of Canada. It would be an honor for me to serve my fellow citizens in that role if my nomination is confirmed. Merci de votre bonne attention.
Thank
Thank you for your attention.
you very much for that. Now we'll begin the questioning, colleagues. The procedure that we've adopted here will go back and forth between the parties, and each member will have in the initial round up to 8 minutes, and then there will be a second round after that of up to 5 minutes. So we'll commence avec mon collègue Jacques Gourde. Monsieur Gourde, it's all yours.
Merci, Monsieur le Ministre.
Thank you, Minister. Honourable Justice Wagner, it is a great honour for me to participate in this final stage of the nomination or the appointment process. Sir, could you tell us, in your 24 or 25 years of experience in practice as a lawyer in Quebec, how that has prepared you for your new role as Justice of the Supreme Court, first? And second, could you also tell us how your experience as Justice in the Superior Court and the Appeal Court has also prepared you for this same role? Thank you very much, Mr. Gourde, for your question. As I mentioned in my opening remarks, I practiced for about 25 years. I was at the Avry, with the Avry group. I had an opportunity to litigate before, or to argue before, all courts throughout the province. And in addition to fine-tuning my knowledge of the system, I learned to argue before courts not only in Montreal but in the regions. I think that I was very privileged to have argued before so many different forums throughout the province of Quebec. This practice, of course, was very intense. I did a lot of commercial litigation during my time. This required close attention to make sure that clients were well served and companies were happy. So as a litigator and legal expert, I needed to serve the interests of my clients, and I learned ways of doing things, and I think that I was privileged in that respect. This intense practice over several years out in the field will make it possible for me to bring to the Supreme Court of Canada experience and knowledge of the community, the legal community. I think that it'll be very useful, and I think that my contribution will be useful because I'll be able to cooperate with all colleagues of the court and share my baggage, my accomplishments, and with other members of the court that bring their own personal knowledge and expertise. And this will be a tremendous system of collegiality, in my opinion. So as 24 years of intense practice before the courts, I have developed a lot of knowledge, maturity, and fine-tuned my abilities that are inherent to the practice of the law, understanding the legal community and the various ins and outs of the legal system of Quebec. You also asked me a question about the relevance of my years of practice in the Superior Court of Quebec. I would add that it was also a very enriching experience to be there. As I said, as a trial lawyer, we were in the line of fire. We had to resolve problems of an immediate nature. There was witnesses that would appear before trial lawyers. It's not the same situation as before the appeal court or the Supreme Court of Canada. And the knowledge of this particular court, I think, will be useful for me so that I have a better understanding of why people make certain applications before the court, and have a better understanding of what lies behind various cases. My practice in the Superior Court also gave me expertise in the area of criminal law as I presided over trials with judges and juries. This was a new period in my life. I had never practiced in that area before, and I had the opportunity to work quite hard, I might add, and to have the satisfaction of presiding over trials by jury. And this practice gave me an opportunity to acquire additional skills, and I think that I will be able to share those skills with my colleagues at the court. I also think that this will be in the service of all Canadians.
Do you have another question, Mr. Gord? 3 of the 9 Supreme Court Justices of Canada come from the province of Quebec. When it comes to civil law cases, the decisions are usually rendered by the Quebec justices on the bench. What experience do you have in this field? Mr. Gord, basically, my work as a lawyer and my practice as a Supreme Court justice has enabled me to work in the civil law and commercial law field. I think, therefore, and I say this in all modesty, but I do think I have good knowledge of these fields. I've had to master these fields as a lawyer, but I've had to render decisions as a judge. And I think that the court decisions involve all 9 justices of the court, and the fact that some have different skill sets from the other will only serve to enrich the court. And even if the other justices do not necessarily come from the province of Quebec, when they have to deal with civil law matters, they do so in a very competent fashion. They do have the expertise. So clearly, when you come from Quebec and you've practiced civil and commercial law in Quebec, obviously you're bringing an additional aspect to the table, which will only add to the skill set of the Supreme Court. I would also add that in Quebec, we're privileged. In Quebec and in Canada in general. And that's what I told the young lawyers where I chaired the swearing-in ceremony. The Quebec students have to deal with both common and civil law. They do this on a daily basis. The Bankruptcy Act, the Solvency Act, the Corporations Acts, therefore, Quebec lawyers are raised with these 2 types of training that come from both the civil law and the common law. So when they become judges, they already have knowledge in several sectors, and therefore they're able to fulfill their duties. 30 years ago, the reality was very different. But with globalization, with trade practices, with all the treaties that are now in place, we see that young lawyers from Quebec are in high demand abroad because they are able to master both civil law and common law, and they also practice law in a sector that comes under the British law system. So there are a lot of advantages. I do come from the province. I had those advantages, and I intend to take full advantage of these skills and to help the Canadian citizens as a result. Thank you very much. Madame Boisvert. 8 minutes, please. Thank you, Minister. I'm going to follow along the principles pointed out by Justice Jean-Louis Baudouin. He said that prior committees acted with a great deal of wisdom and reserve. I'm going to try and do that. I will try, because we do understand the concept behind these hearings. Congratulations. We all know that we are here to introduce you to Canada. In Quebec, people are more familiar with you, obviously. Some of my colleagues here do come from Quebec. They know you. But personally, I'd like to congratulate you on your nomination. You have a very interesting background. The only criticisms, well, you're not a woman, and I can't blame you for that. So we should blame that on your father, perhaps. But let's get to serious things. But you have two other justices to appoint in the future from Quebec, so I just don't want you to forget about that. Inaudible for the interpreter. I'm very pleased to hear you say that. Mr. Gord talked about your experience as a civil lawyer, but I'd like to push it a little bit further. How do you see the importance of civil law within the Supreme Court of Canada? We all know that there are three positions representing Quebec. There are 3 seats allocated to Quebec. So how do you see the civil role within the Supreme Court of Canada? Thank you, Madame Boivin. It's an interesting question because the way the law is written, yes, there are, in fact, 3 judges that come from the province of Quebec and who are more familiar with civil law. But there's also a reality that's quite new, something we've only seen in the past few years, and that is that there are some philosophical differences between both common and civil law, but because of globalization, we can see there's more of an exchange going on between the various systems. We're realizing now that in some of the common law provinces, even in foreign countries, who are going to take some principles that we see in the civil law system, and these principles are in turn influenced by common law. So we can see this happening. So the very fundamental changes or differences that we may have noted a few years ago are not so obvious today. All this to say that even though there are only 3 Quebec judges on the Supreme Court bench, the other 6 judges are also very competent in the area of civil and common law because of this evolution and because of their open-mindedness. And so I don't view this as being a sine qua non condition. That is, just because you're not from Quebec, you're not able to understand the scope, value, and merit and determination of civil law in Quebec. So you're not saying that it's that the people who want to protect civil law must absolutely come from Quebec. Just the opposite. It's important that we ensure that civil law of the province be taken into account. Another question. When we look at your CV and we see all of your practical experience, we have a similar background. I came from the U of O as well, so good for the U of O. But that being said, when we look at your CV, we can see that, yes, you were a Superior Court judge in 2004. You were appointed to the Court of Appeal just last year. So how do you see yourself making this step to the Supreme Court? Do you feel you're ready to make this jump? Thank you, Madame Boivin. I always like to say that I prefer quality to quantity. In other words, even though I've only spent 1.5 years on the Court of Appeal, I can tell you that this was a very intense period of time. You have to be careful when you're talking about length of time. If I had spent 15 years on the Court of Appeal, I think you may be fair in saying that that's 13 years more of experience, but my short stay at the Court of Appeal is, however, a sign that I am prepared to make this step to the Supreme Court. Let's not forget that this collegial type of work, and you must understand that we do work in a very collegial fashion at the Court of Appeal. It's extraordinary, but I can't say that this was my first experience to work in this first time I ever worked in this fashion at the Superior Court, particularly in the criminal court. We worked on a collegial basis, not for rendering decisions, because the decision must be made by one sole judge, but there's a lot of collegiality in terms of management, in terms of the hearings, in terms of the criminal files, especially when you're talking about mega trials. So we had to work together. So you shouldn't look at my stint at the Superior Court as being the only evidence of my ability to work in a collegial fashion. I think you have to look at the entire CV. You have to look at the number of years that I practiced. You have to look at my involvement in other activities. I think I've been able to show my will. I've never stood back from a challenge. So you're not intimidated by the challenge? No, not at all. I'll do my best, obviously. And I'm very enthusiastic about the prospect of working with other Supreme Court justices. Do I still have time remaining? No, that's it.
Welcome, Justice Wagner. As a lawyer myself, and I guess if we're plugging universities, trained at McGill University in both legal traditions, civil law and common law, I couldn't then, and I'm not sure I can now, think of a greater responsibility, a greater exercise, and as a lawyer myself and member of Parliament, the opportunity to be involved in this process. And I just want to thank all members of the selection process whom I worked with this summer. The lasting friendships, bond, and mutual respect that we gained for each other, if I may say so, was a great experience. And of course, to our advisors. Justice Wagner, as a trial judge, you had the opportunity to develop and demonstrate considerable expertise in criminal law. Part of criminal law is sentencing. And we know that Section 718 of the Criminal Code identifies the fundamental purpose of sentencing, the maintenance of a just, peaceful, and safe society. And then it goes on to list several objectives, which I know, of course, you're very familiar with. But my question to you is this, Justice Wagner. As a trial judge, how were you able to take these objectives into consideration in arriving at a sentence, considering at some points from time to time these objectives may have competed with each other in certain cases?
Thank you, sir. A very important question that you just raised, because, you know, I always thought that when I was called to preside criminal trials, the most difficult process was the sentencing. After, of course, the accused was found guilty, for instance. It's a difficult process, it's a sensitive process, because it calls for an amount of discretion, not for arbitrary decision, but discretion, judicial discretion. And that's not easy. And I always preferred to look at it under the light of fairness. Is the sentence fair, given all the circumstances? You were right in saying that paragraph 718 and following of the Criminal Code gives the judge a lot of tools to work with and to decide what is the most appropriate sentence for this case. We should never forget that the judge will not sanction only the crime, he will sanction the criminal. So he has to to give proper light to the full picture, prior records, type of crimes, was there violence, and so on and so forth. And at the end of the day, given all the evidence, he must come to the conclusion whether what would be the fair sentence in this case, the adequate sentence given the profile, given this specific case. So I never looked at it as being, is it a tough sentence? Is it a lenient sentence? And sometimes, a fair sentence can be a harsh imprisonment, whereas a fair sentence can be a lenient sentence also. So I prefer to look at it under the light of fairness. Is it just? Is it fair? And that's one principle that guided me throughout those years.
Thank you for that. Justice Wagner, then as an appellate judge, how did you approach appeals related to sentencing in criminal cases? What additional comments would you like to add with respect to that?
Well, I think that the law has been well established up to now. I think that the appellate court should not and will not intervene, usually, unless the trial division judge or the first instance judge made the blatant mistake or did not interpret correctly the criteria when imposing sentence. So the reason is that, of course, the first instance judge must have his way out, his way of doing things. He's got his own discretion. I think that the appellate courts should respect that discretion and will only intervene in real special cases. And maybe the appellate court would not have imposed the same sentence. That's not the criteria. Does it go beyond a significant error? That would be more the criteria.
Okay, thank you.
Maintenant, nous avons Stéphane Dion.
Stéphane Dion. Mr. Dion. Thank you, Minister. It's a pleasure to hear from you and to read you. But one thing that struck me is the extreme importance that you have given to the principle of judicial independence. And in addition to that, there's this whole issue of the presumption of innocence. What really struck me was that you have to view it from the court's perspective and from the context of society in general. There is an article, Liberté, that you produced in 2003, and you said in quite concrete terms, and I'd like to quote you, when the media decide to judge a person or company in the public forum, and if this person or business is acquitted, well, generally speaking, the media is the harm done by the media is extremely hard, and there's no appeal, and this should lead to sanctions. So where does this concern come from? Why are you so concerned about the presumption of life? Was there something in your life or in your legal practice that made this so fundamental for you?
I think it's for a whole host of reasons over a number of years. But at the end of the day, it's a question of balance. When you talk about independence and impartiality of the judiciary, when you talk about the presumption of innocence, these are principles that are very delicate. You can't play with that. Our democratic system survives and develops because there is a social consensus, because individuals accept at an individual level to subject themselves to authority. When individuals stop voluntarily subjecting themselves to authority, anarchy will ensue. And this is where the line is fine between anarchy and the opposite to anarchy. So citizens have a willingness to submit themselves to the legal system, but they also have to be confident and trust the legal system. In order to trust the legal system, it has to be credible. and to be credible, it should not be unduly attacked. So everyone must do his part. It is not the role of a single entity or a single person. The credibility of the justice system is fundamental to ensure that each and every person that appears before the court has the satisfaction and the conviction that he or she will be heard and that their justice will be done. Not necessarily that the individual will win, but that justice will be done. And the problem is when these individuals lose faith in the justice system, we end up with all sorts of problems, as you could well imagine. So in the administration of justice as you conceive it, the presumption of innocence puts the burden of evidence on of course, the accused. Is this a principle of natural justice for you, without which justice would not work? Well, this is a societal choice in any case. In Canada, we chose to adopt that particular principle. It is a noble principle, but it is a societal choice first and foremost. In other societies, there are other principles adopted. In Canada, we seek to ensure that Canadians are not unduly convicted or wrongly convicted, and the onus is on the public department to determine the guilt or otherwise of an individual. This presupposes that there are cases where accused persons who are guilty will be acquitted, or where they will be found guilty of a second-order offence, because the prosecutor hasn't been able to establish that the person is guilty beyond all reasonable doubt. And I think that courts need to apply the rule of law. It is a very noble foundation of society which sets us apart from other societies. I know that there are exceptions, the presumption of guilt, where the onus of proof would be on the defence. There are certain cases where that would be acceptable. I think that there are examples where the burden of proof would depend on the offence. For example, well, giving you my personal opinion would be philosophical. I gave some of my opinion earlier, but I think that it is not my role here to provide you with philosophical opinions, beyond what I've already said, of course.
Monsieur le Juge Wagner, bienvenue.
Justice Wagner, welcome. It is an honour to be with you here this afternoon. I'm also very proud to be a lawyer. I am a graduate of the University of British Columbia. Our modern criminal legal system is essentially considered a process of contradictory debates between the prosecutor and the person accused of a crime, most often represented by a defense lawyer. What, in your opinion, is the role of a victim of a criminal act in our criminal justice system? Well, if you're referring to the active role of the victim, I think that the provisions of the criminal code, as they currently are, set out already a number of considerations regarding the victims of crimes. In criminal trials in Canada, at the stage of the administration of evidence and at the level of the sentencing, I think that the impact on the victim can be taken into consideration by the judge who is presiding over the trial. I think that currently there is already discretion. The judge already has a certain level of discretion, and the judge must apply the law as it is. As a judge, what can you do to ensure that the rights and interests of victims of crime are respected? Well, I think that the law needs to be applied, whether it is a trial judge or a judge at the Supreme Court. The law exists and judges must apply the law. Sometimes it's not easy to apply the law or to enforce the law. And I think most judges will try to enforce the law to the best of their ability. And as I said, there are already provisions in the law, in its generic sense, of course, that refer to victims' rights. And I think that the courts must apply the law, and it is up to parliamentarians to enact legislation. It is not up to the courts to do so in their place. Pierre? Thank you very much, Honourable Justice Wagner. The quality of a justice is to hand down well-reasoned and well-written decisions. Some decisions are succinct, some are longer, some are more exhaustive, some are more fleshed out. So the important thing is to be understood in the legal world and by the public. What can you tell us about your particular writing style, sir? Well, I can give you my own appreciation, but somebody already said, do not say a little in many words, but a great deal in a few.
Je pense que c'est l'objectif qu'on devrait, que j'ai tenté de rencontrer, si vous me permettez l'expression, au fil.
I think that's the objective I've tried to meet over the years. There are situations where the issues are complex to the extent that it is not easy in a few words or a few sentences to provide an opinion. And I think the role of a judge, the role of the Supreme Court, in fact, is to be the standard bearer of the Charter and legislation, but also to provide opinions that are well informed, not only regarding the law, but also to provide direction for the future. And I think that it is important that decisions be written in clear language to enable persons subject to trial to understand whether why they've lost or won, and what the impact of these decisions in the future. Everything depends on the circumstances. There can be no general rule as to writing style. Personally, I've always tried to write my reasons in a clear fashion, and it is up to persons subject to trial to decide what they think of that. My second question is the following. When you look at the Supreme Court of Canada in its current state, what are the qualities that your appointment might bring to the Supreme Court of Canada that are original, that are not currently there? Well, that's quite a question you've thrown at me. I think I'll answer with humility. I've noticed that the justices of the Supreme Court are wonderful legal experts. These are people who are very noble of spirit, and I think that it would be a tremendous challenge to be among their ranks. We all have our characteristics. I would not presume to say that I would bring something to the court that isn't already there. My only contribution, and this is my personal conviction, as I've done in the past, I would not hesitate to work hard. I think that is a commitment that I can stand by. I will bring my own cultural and educational background, my background of life experience and practice, my legal experience, and I will work alongside the judges that are currently there. Do I have any time left? My final question is regarding the writing of a number of papers, participation in conferences, and so on and so forth, how has that prepared you to take up your role as a Supreme Court of Canada Justice? I think that the situation in Canada is not what it was several years ago, but society has evolved, and the role of a judge has evolved in society. It is important that judges be able to participate in the way things are developing and to express opinions on the justice system. Perhaps this role wasn't very visible 15 or 20 years ago, but increasingly we're seeing that judges are participating in the way society is developing. And when it comes time, they should not hesitate to appear at conferences or write articles about the justice system, while of course maintaining their impartiality and independence. So over the years, I have been called upon to speak to major issues, and I think that is part of the role of the judiciary. And I don't think the role is to be a sphinx, but it is a proactive role within the limits of our jurisdiction. Thank you, Honourable Justice Wagner. Thank you, Minister.
Tout d'abord, félicitations et
To begin with, congratulations, and this meeting will provide Canadians with an idea of your knowledge. You have tremendous experience in litigation as a judge. You'll agree that it's always more pleasant to ask questions than to answer questions. My question is about the Charter of Rights and Freedoms. What challenge does the Charter provide with respect to Parliament and courts, especially when it comes to striking a balance between the rights of individuals and the rights of the state? Once again, it's about striking a right balance. In life, it's always a question of balance, isn't it? And I think it is all the more true when it comes to the law. I think that the role of the Supreme Court is to be the guardian of the Charter of Law and of the Constitution. The court must sometimes assess, when there is litigation before it, an interpretation of certain specific laws regarding issues. Now, this interpretation isn't set in stone. It is a process that evolves with the way, as society develops. There is no legal priority in that consideration, and I think that it requires of all judges an assessment of the situation in terms of the facts, and this will mean that certain laws are considered to take priority over other laws. It is not an easy exercise. If I look at the decisions of the court over recent years, you won't be surprised that I'm quite proud of how the court has conducted itself. There have been wonderful decisions handed down that were well researched, especially with respect to the First Nations. And this isn't an easy exercise. I think that it is a question of striking a balance. In your opinion, what have been the major repercussions of the Charter over the years? Well, listen, the Charter has changed the society as we know it. I think that there have been interpretations by the judiciary that have been led to various new laws. I think the Charter, from its adoption in the 80s, has had an effect, and I think that its impact is continuing to develop. Romeo Seganache. Thank you, Minister.
I'll do the translation myself. Merci d'être ici. Félicitations.
Thank you for being here. Congratulations. And please say hello to Julien. I met Juliette. I'm not from the University of Ottawa or McGill. I'm from UQAM. The University of Quebec in Montreal should be included in this discussion, shouldn't it? Justice Wagner, I come from a world where at a particular time the concept of the rights of Aboriginals were quite unknown. The Bay James case argued the rights of Aboriginals before the courts. It was quite a rare thing at the time. And I'd like you to talk about your experience with Aboriginal causes, if you do have any. You just mentioned the importance of this. Quite recently, Federation of Law Societies of Canada, I don't know what the French equivalent is, they adopted a recommendation that all new lawyers in Canada have knowledge of or familiarity with the rights of Aboriginals. Do you consider that this is a reasonable recommendation, a useful recommendation for the future of our justice system for the Aboriginals in Canada? Thank you for your question. I'm pleased you asked it. You're right. Now, to the last part of your question, I think that knowledge is never a bad thing. The more information you have, the more information Canadians will be able to acquire regarding the First Nations, and that will be the best scenario, regardless of what the information is. So I think that ignorance is the root of many biases and prejudices, and I think if people have access to relevant information about the First Nations, then it's a good thing. Now, you touched on a very important point. There has been a tendency in Canada for far too long, in my opinion, to consider there are two founding peoples in Canada, Anglophones and Francophones, and we have forgotten the First Nations in this mix. It is a reality that is disappearing in the public discourse. The Aboriginal peoples have taken their rightful place, and I think that this is thanks in large part to the Supreme Court. I'm very pleased about the decision the Supreme Court handed down regarding the place of Aboriginals, and I think this is testament to the recognition of the place Aboriginals must have in Canada. I have no time left.
I'm sorry, you go right ahead.
Now, with regards to Aboriginal rights, international law is influencing Canadian domestic law in terms of human rights and other areas of the law. There's an increasing influence. And I agree with you regarding your balanced approach. For 23 years, I was involved in the negotiation of the rights of Aboriginal peoples in the United Nations. This has lasted for 23 years. If a document of international law protects the rights of third parties, then I think that is a good example of striking a balance. Do you have any experience in international law?
International law. Well, international law covers many different fields. I recall even when I was at the Faculty of Law, there were a lot of students who were saying, I want to do international law. Yeah, but international law, it's something else, really. It's something that we find in our files, and arbitration, especially when you're dealing with other countries. When I was in commercial litigation, I came across international law, especially when you're dealing with foreign legislation. So I've already dealt with this, particularly when I was in commercial law. This is occurring more and more frequently. Because of globalization and trade relations, we're often called on to look at the enforcement of foreign legislation. That's international law. It's not necessarily public international law. You're not dealing with treaties per se, which is a source of influence. There's public international law, private international law. Now, all countries throughout the world, we can't live in silos. We're all influenced by other treaties, which may not concern us initially, but do concern us indirectly. So international law, well, as a lawyer, I came across it in practice. And sometimes when I was a judge, there are criminal treaties which trial judges have to get involved with. For example, extradition treaties. So we have to enforce the legal statutes of other countries. Thank you very much.
Thank you, Minister. Welcome to our committee, Judge. I wanted to follow up on a bit of the line that my colleague Mr. Gauguin was taking in his question. 80 years ago, in the famous Persons case, Lord Sankey wrote what I think is the best-known piece of obiter in Canadian jurisprudence when he said, and I quote, "The British North America Act planted in Canada a living tree capable of growth and expansion within its natural limits," end quote. And this is often taken to mean that the courts can and should alter the meaning of parts of the Constitution so as to allow it to, as one court has said, accommodate the realities of modern life. But until recently, the courts took a very different view. For example, I have a quote here from a 1937 ruling of the Alberta Court of King's Bench in which the judge ruled, and I quote, "None of the observations of Viscount Sankey can be said to provide legal justification for an attempt by Canadian courts to mold and fashion the Canadian Constitution by judicial legislation so as to make it conform according to their views of the requirements of present-day social and economic conditions," end quote. I'd be interested in your views on this subject.
Well, that's a big subject, and it calls for opinion, personal opinion, philosophy, and it is quite possible, not possible, but probable that the Supreme Court will be called again to interpret the Constitution. And with all due respect, I would like to be part of that debate and that decision. So I would prefer not to comment on this question at this time.
Okay. Another question, but it's basically a different version of the same thing. So perhaps, Mr. Minister, I'll turn it back over to you to go to the next person.
Thank you very much. And Philippe Thune, avez-vous des questions?
A question, Mr. Philippe Thune. I appreciated Mr. Reid's question. It's not the first time this question's been raised. Thank you. Thank you for coming here. Thanks to both judges. It's quite an honor to be here in your presence. If I can make a plug for my university, I did my training at U of O as well. I think that the University of Ottawa is very privileged in that it has access to unbeatable resources, namely the Supreme Court of Canada. So I think that people who study at the U of O are very lucky as far as that's concerned. My training at this university gave me a better understanding of the bi-jurisdictional process of Canada, or the two systems of law, rather. Those who have just a civil experience, such as the Cour de Cassation in France or Belgium, often their decisions can be summarized on one page, but that's not the case here, particularly with common law jurisdictions, where we have this two legal system. Often the decisions go on for page after page. But I think there's been a recent trend, particularly under Chief Justice McLaughlin's reign. There's been an attempt made to summarize more. We've seen some decisions that were written by several justices, and different arguments are given because every justice has his or her own reason for coming up with a decision. So how do you see this playing out? You talked about the collegial nature of working at the Court of Appeal. But the Supreme Court is even more so. Do you think that you will be drafting decisions in cooperation with the others? How do you see it? I would say that it's the same process as you see at the Court of Appeal or at the Superior Court. The role of the judge to explain the reasons that led him or her to make this decision. As I said earlier, some files are more complicated than others. And the higher you go in the legal hierarchy, the more complicated the cases are. And the Supreme Court handles very complicated cases with very serious legal consequences. But the principle remains the same. You have to draft your decision and let the parties to the suit and the litigants know why you've reached that conclusion. And there can be some nuances. With 9 justices, it may be more complicated than with 3 justices, but there's more resources. There are more resources available. And therefore, you have access to a greater wealth of ideas. You have access to the thoughts of 9 justices. And so I think that each case has to be viewed separately. There are perhaps some instances where you're going to have to draft short decisions, but in other cases it won't be possible. It's a question of striking a balance of compromise. When you bear this in mind, I think that there's always a way to work together well. I appreciate your answer. I agree with you. The Supreme Court has a duty to make sure it is well understood. We want people to have confidence in our legal system. I think that's part and parcel of what you were saying. As for the training, when I trained, I got training in the use of computers. So I don't recall exactly what you were saying. You talked about the Center of Access to Information. You called it the CAGE, I believe. Could you talk a little bit about this center? What role do you see these computer resources playing? Is your role to not necessarily to put everything in layman's terms, but to make legal study more accessible here in Canada? How do you see computers and automation playing a role?
Qui renseigne
Does the Supreme Court use these systems more often? If we do have access to the decisions, we can see how things are heading. Do you think we should expand our system? And if so, how? How do you see the computer system for law in Canada? When you talk about major issues in the Canadian legal system, it's definitely access to justice, in my opinion. Access to justice means access to information, legal information. Earlier, we talked about training. The more training you get, the more we realize we need. And that's true in the legal sector. We went through a period where information was limited to just a certain number of people, but with online learning, with computers, I think there are fewer reasons now to limit this information. It should be accessible to everyone, and everybody has to play a part in this, including the bar associations, the governments, the media. But I think that the courts, within the purview of their jurisdiction, should also take steps to disseminate information about their decision. I think in the case of the Supreme Court, this work is being done very well. That doesn't mean we shouldn't try and improve it, but I do agree with you that access to legal information is essential to ensure access to justice. That's what we did in 2000, 2001. And I'm very proud of what we accomplished, because at that time, we were taking a leap of faith, if you like, because the Montreal and Quebec City did not have the same interests as the regions in Quebec. But we were able to have a common objective, and we wanted to have access to information that was provided by professionals. Now, every judge in the province has his own library just on his desk, and that's very important when we talk about access to justice. I think that these efforts have to be continued by everyone, every player in our legal system. Thank you very much.
Monsieur le Ministre.
Thank you, Minister. Thank you.
The Justice Wagner, you know, your last words about accessibility and your presence here and the role of Master Baudouin and of the Minister, I think has really elevated people's appreciation of our justice system and hopefully our respect for it. So again, thank you. Monsieur le Juge Wagner, en passant.
By the way, I noticed that in your first and perhaps last election, you got you won 91% of the votes. We are representatives of a profession that is very competitive, so I'm sorry that you only got 91%.
Different ways about accessibility, and I was particularly touched by your account of the meeting you attended in New York after 9/11. In that case, you were talking about accessibility, perhaps financial and operational accessibility to the courts. You also used a very trenchant expression, don't say a little in many words, but say much in a few. Many of the decisions you would be involved in would be fact-specific. They'll touch the whole nation, though, and I'm wondering, as a British Columbia lawyer, where we've spent a lot of time in the profession looking at plain language, whether you have some thoughts on expressing judgments in a way that will be accessible to the nation so that they can understand what our Supreme Court is saying.
Well, I appreciate your question, Mr. Weston, because you know, when we're talking about access to justice, one of the first criteria is to make sure that the judgments, the reasons, are not only well delivered, but that are clear enough and could be understood by everybody. As I mentioned earlier, you know, sometimes it's not easy to simplify things too much. They are very complex issues. and sometimes the good decision will justify longer sentences and to cover adequately the complex issues. But at the end of the day, I think that if everybody keeps the same objective, to make sure that the information, the reasons are clear enough, I think that we could manage, in most of the cases, to deliver judgments clearly, and to make sure that, of course, they are well understood by the population and not only the lawyers.
Thank you for that. You also touched on several occasions on the independence of the judiciary and how important that is. I wonder, given that independence can also be isolating, how you, as an appeal judge and as a potential Supreme Court of Canada judge, would stay connected to average Canadians?
Mm-hmm. That's a good question, because, of course, we have to protect independence and impartiality. But as I mentioned before, the judge in 2012, whether it be a 12th Division judge or an appellate court judge or a Supreme Court justice, I think must also participate in this evolution of society, not only by mainly rendering judgments, that's the first duty, but also to take the opportunity that is presented to him or her to let the people know what they are doing and explain to the people, what does that mean to be a judge. And it's part of the public education, which in itself will be able to maintain the credibility of the justice system. It's only one element, but it's an important element. So in that sense, I think that it is true you have to maintain independence and impartiality, but that doesn't mean that the judge could not deliver speeches on the merits of our judicial system. And I think there's a way to maintain both, to maintain the independence and also to contribute to the credibility of our system.
Noble goals. Thank you very much.
Thank you,
Mr. Chief Wagner. Merci.
And thank you very much, Mr. Weston. Colleagues, we've gone through the questioning here to begin with. I'm in your hands. We can take a 5-minute break if you like, or we can continue to the second round. We'll keep going, race right through? Okay, colleagues, thank you very much. Is that okay with you, Your Honor? If we continue here, we'll continue. Okay. Colleagues, we'll go for the second round. Mon collègue, Monsieur Gord, maintenant.
Mr. Gord. Thank you, Minister. Justice Wagner, with our civil code and common law tradition, do you think that either one of these systems may have an impact on the decisions rendered? And do you feel that Supreme Court justice can use this case law, whether it be pertaining to international law or property law? Do you think that it is an advantage to have these two pillars of law, or perhaps as compared to, let's say, the French example where you have just the one code? It's a big advantage. Often, the people who benefit from this know the least about it in some respects. We have to inform people about the wealth of our system. We have a common law and a civil law system. And unlike other countries, with the evolution of trade and international relations, we are very lucky here in Canada to have these dual foundations, to have these two different legal systems. And the Supreme Court enables us to appreciate various cultures, various legal systems that are different, that other nations simply can't do. So we have a clear advantage here. And I think that every Supreme Court justice is very sensitive to this. And as I said, it's a source of wealth because of the globalization of international trade, because of the influence of civil law on common law and vice versa. Well, we now deal with this on a daily basis, and I think the court is well prepared to do this. Thank you. Thank you very much, Mr. Gaud. Do you have any questions, Madame Boivin? You're lucky we have you for 3 hours. Before we only had 2 hours. I'm not complaining about that. You put your finger on one of the most important issues in Quebec. I know that the current head of the bar mentioned this before he was elected, and that is the rule of law, accessibility to the legal system. These are concepts that are very important, not just in Quebec. I could easily see that this applies to the rest of Canada as well. You talked very briefly, and we read about this in the papers. You wrote a letter as the head of the bar to defend the independence of the judiciary, which is fundamental as far as I'm concerned, in order to have a proper legal system. I'd like you to elaborate on that. And secondly, how do you see the role of lawyers who plead their cases before you, who litigate before you? You've got your ideas about a matter. You have to be able to react quickly. Do you have an ability to change ideas? Have you already had an experience where someone before the court who was appearing before the Court of Appeal said something and you thought to yourself, gee, I never thought of it that way before? I can reassure you, Madame Boivin, I can guarantee you that this did in fact happen to me at the Court of Appeal, where the initial impression I had was changed by a hearing, by the argument. We read a lot when we're sitting on the Court of Appeal bench, and so I do have an open mind, and colleagues are always saying that there's a reason for that, precisely because of situations where we haven't understood the file completely, and when you hear what different colleagues have to say. So by doing all of this, we reach a good decision. So it's fascinating to see how colleagues, and I don't have any reason to believe that's not the case with the Supreme Court, even though I haven't been there yet. But we have to have an open mind. Of course we look at the files, we study them. Obviously, we have an initial idea of what we think the issues are and how things will go. But we have to remain open. We have to always be open to the possibility that our initial impression might not be the right one. So you can will you need an interpreter to listen to I don't think so. It would surprise me if and independence in your letter to the press. As I said earlier, I'm a big advocate of the independence and impartiality of the judiciary, because that's the guarantee of our democracy and our freedom. In Quebec and in Canada, this is something that we take for granted. And it's unfortunate that we take this for granted, but yes, we have to think about that. And often that can be found in the little actions that are taken, and these accumulate, and at one point we no longer have this consensus that is essential to ensure that the rule of law continues to apply and that people don't resolve their issues outside the court. But it's rare for a judge to write to the media and to say, that's enough. We have to be careful here because it's rare. I've not often seen judges who've bothered to write letters to the media.
Well, that would, of course, necessitate particular circumstances, but there hasn't been any gratuitous or pointless attack of the... There was a case with a very good judge of the Superior Court. This led to a conference of the justices of the Superior Court, and there was a reaction to that. It wasn't a letter that was addressed to the media per se. It was a letter that referred to an incident. But my letter would or in fact, the justice system isn't sheltered. And I think that it's important that litigants and media be able to criticise the justice system. It is a fundamental right, the freedom of expression. But it's a question of balance. We always come back to this question of striking a balance. In that particular case, there was a lack of balance, and I like to warn people about not bearing this in mind.
Monsieur le juge Wagner, comme juge...
Justice Wagner, as a judge at the Court of Appeal, when you found an error in law at the trial court, trial division, what principle did you use to determine whether a case should be returned as a new process, or whether the decision should be overturned based on the principles of correct principles of law? Well, basically, the test at the appeal court is to determine or identify whether a decisive error was made by the first judge in applying the law. There are several factors that need to be taken into consideration, not just that error, which is of course decisive and important, but one needs to bear in mind what the ramifications of the error are. It is not a limited review, and it is not necessarily the same review in all areas of law. There's family law, commercial law, criminal law. Of course, in the area of criminal law, normally, where there are judge and jury trials, if there has been an error in directives, can reparative justice measures be put in place? Should there be a new trial, for example? There are several stages that need to be put in place when an error has been identified. Sometimes there are criteria for a new trial, for example. In the civil realm, there are also criteria. So, of course, the error is important, but an appeal court must defer, in most cases, to the trial court. In terms of the credibility of witnesses, the trial judge is the person that listens to the witnesses and will determine the credibility. The appeal judge, the Supreme Court judge, doesn't have the same appreciation from his or her standpoint. At the criminal level, the sentencing in sentencing matters, the judge needs to display deference, and it's only when the sentencing seems to be not in line with what would normally be handed down as a sentence that there is an intervention. Stéphane Dion. Thank you, Minister. You, in your discussion with us, have attempted not to cross any lines and give us an insight into decisions that you might make. And of course, we don't want you to preempt your decisions, but if you could clarify the role of a judge outside these decisions. A judge has a role in society to play. Can a judge play a role in society outside of his or her judgments or decisions? For example, is the onus on a Supreme Court justice to ask a question regarding the debate in the Parliament regarding the bilingualism of the Supreme Court? Is this an issue that you should have an opinion on, or should you be quiet and allow this debate to play out in Parliament? Well, I'm a nominee to the Supreme Court, and so I'll speak as a nominee only, and I'm not going to directly or indirectly criticize any future colleagues of the Supreme Court. But I think that on political issues, I think that a judge needs to be careful never to cross a line like that. We don't want politicians either to meddle in the areas of the judiciary. So I agree with you that sometimes that line is a bit fuzzy, and sometimes the judiciary might make comments that seem political and vice versa. But if people act in good faith, as we presume they will, normally there shouldn't be too many problems. And when I stress that a judge is no longer the Sphinx judge that he was or she was in the past, you know, it doesn't mean that it should be talk show interviews and magazine interviews each and every day. It just means that in his or her role as a judge, in maintaining deference to keep his or her credibility, in order to not interfere in public debate in his or her area of jurisdiction, the judge must bear in mind that it's important to keep the public informed and educate the public. As a judge, I have been at information fairs, the Barreau de Montréal, at the Complexe des Jardins, organised these kinds of fairs. The bar invites judges from the various Quebec courts to meet with Quebecers and Canadians. Sometimes it's to preside over a trial, sometimes it's to explain the role of a judge, and I think that this is absolutely crucial. This kind of thing didn't happen before. It wasn't the role of a judge in the past, and I think that it is useful that a judge has such a role, and I would leave it at that. And you have any time left? 1 minute? Well, everyone has talked about their legal background. I'm not a lawyer, but I have a background in social science. How would that serve you in your career as judge and as in your career as a Supreme Court judge? Well, I can tell you that it was very useful to me. I studied at the University of Ottawa. I had excellent teachers and I have very good memories, both in political science and social science and in law. It was an exceptional environment in which to study, and what I've derived is great knowledge. I've always claimed that the more knowledge you have, the better equipped you'll be for the future, and comparative law knowledge has served me well. Studies in political science and social science have enabled me to understand the foundations of foreign systems and foreign political systems, and enabled me to compare the legal and political systems. In comparative law, we had classes on legal systems. To answer your question, I think by comparing systems, I was assisted in my practice as a lawyer, as a trial lawyer, and also as a trial judge, and also as an appeal judge, and I think it's very important.
Questions?
Monsieur Wagner. Je propose les certains délais.
So, obviously, there needs to be preparation in preparing to work in the legislature, unlike in some countries like in France, where people study at the École Nationale to become judges. But we've had the pleasure of looking at reviewing your background. Could you tell us what your mentors, who your mentors were? Were they judges or jurists who have had an influence in your life?
J'aurais tendance à vous dire que ma plus grande influence, là.
My greatest influence was my father, in fact, for several reasons. Not just because of his legal or political activities. He was an excellent judge and a lawyer, one of the best in his era. He had his morals were strong when it came to legal principles. I try to apply those qualities myself, and I've tried to do so since I have been a lawyer and a judge. And I think that open mind is important as a judge. And my mentors over the years gave me tremendous advice. Paul Carrière and Jacques Chauvelin assisted me, and I met them in the appeal court, and they gave me tremendous advice. At the Supreme Court, I'm going to be careful because I don't want to make anybody jealous, but I can tell you that I've always appreciated the way Justice Gontier has drafted his decisions. He is a tremendous legal expert, and he translates his thoughts into very clear, understandable terms that are understood by lawyers and by the public, and he has inspired me over the years. Thank you. Thank you. My first question, just a preamble. Everybody has referred to their CV. I'm not going to do so, but as Maître Eganache, I'm going to do so. I studied in criminology, and I understand the importance of a multidisciplinary approach in the practice of law and in the everyday life. My first question, in one of your conferences, you talked about the importance of the independence of judges. In one of your conferences, you seem to guarantee the independence of lawyers. How is an awareness of these fundamental principles going to help you in your future role as a judge? I think that it's important to never forget the foundations of our society and our democracy. Judicial independence is one of these principles. Also, the independence of lawyers is also very important. It's been noticed in societies, in other societies, that the first persons to suffer in systems of tyranny are judges and lawyers. And the purpose of that is to stop people from having their rights upheld. And that's what happens in countries where tyranny reigns. And that's why it's important to assure the independence of judges, and also why it's important to have a solid bar association in a democratic country, because it is a indicator of that. Now, as far as a lawyer who would appear before the Supreme Court of Canada, what do you see as the human side of a judge in the Supreme Court? How do you see that? Well, you just don't stop. You don't lose your human characteristics because you're a judge. You try and apply them for good. When lawyers appear before courts, whether it is a trial court or the Supreme Court or an appeal court, a lawyer has to be well prepared. And this is true at a trial level and in the Supreme Court. Of course, the stakes in some cases are greater in the Supreme Court, but this has no effect on the obligation to prepare. It is a duty to be well prepared, not only also for clients. And my advice is to ensure that lawyers are well prepared. Third question. You handed down decisions in the affaire Vincent Lacroix, Jacques Delisle. These were very controversial. Now, your experience in managing this kind of stress with media being involved, how will that experience help you in your future role? Mr. Baudouin pointed it out in his opening remarks. Judges aren't there to be popular. That's why judges are apart from others. They are there to be independent. when a judge a judge has to be able to make decisions in in files or cases which attract a lot of media attention. It's not the judge's role to hand down a popular or an unpopular decision. When a judge is involved in a case that gets a lot of media attention, there might be added pressure. But I think the objective is the same, whether it is a case that is attracting a lot of media attention or not. That's how I've always approached it in any event.
You represented a lot of individuals and companies in your practice. You've defended their interests. How do you view this as being an important aspect of predictability for corporate interests? Stability is very important. As a commercial lawyer, I learned that it is very important that we look after the interests of the parties, whether they be corporations or individuals. There are all kinds of dimensions to this and all kinds of consequences. First of all, we have to base ourselves on case law in rendering a decision. So these decisions allow for a certain stability, so people understand the legitimate interests here. And I think that plays a big role in assuring this stability. But things do evolve. The decisions have to be sufficiently clear so that the parties to the suit, whether they be individuals or corporations, they'll have a good idea of what to expect. Thank you. Romeo Seganesh. Thank you, Minister. I'd like to continue along the same line. I found your answer most interesting. In two of the decisions made at the Appellate Court and at the Supreme Court under Justice Labelle, these were cases that involved sentencing. I can even read an excerpt from the decision. It says in this decision,
notice of such matters as the history of colonialism, displacement, and residential schools, and how that history continues to translate into lower educational attainment, lower incomes, higher unemployment, higher rates of substance abuse and suicide, and of course higher levels of incarceration of Aboriginal peoples. Aside from sentencing issues, what are your thoughts on how quote-unquote justice can be effectively achieved through the Canadian courts, in your view?
Well, I think that the Supreme Court, you just referred to one case of Gladu, but there are many other court cases from the Supreme Court. And as I mentioned earlier, I'm very happy with the way the Supreme Court delivered its decisions with respect to the First Nations. I think that the court applied the law. And maybe for some people, the application of the law is creation of the law. I don't think it is. Because the creation of the law is for you, Member of Parliament, to do. It's not up to the judges. So I'm satisfied that the law can be applied by judges. They did in the past, and I'm confident for the future. And I wish I would contribute to that effort.
Monsieur le Ministre. Merci.
Thank you, Minister.
Think how I could ask the same general kind of question in a way that would make you feel that you can be comfortable giving a response. So let me give this a try. and obviously I'm not asking for a response with regard to any particular question you might be deciding. About 30 years ago, when he was, prior to the Charter actually, when he was dealing with a question relating to the division of powers, the then Chief Justice, Justice Dixon, stated, and I quote, "If the Canadian Constitution is to be regarded as a living tree, and legislative competence as essentially dynamic, then the determination of categories," by which I think he means heads of power, "existing in 1867 becomes of little other than historic concern," end quote. In other words, he was looking at the possibility that the courts could, in order to achieve a more effective federation, adjust the legislative competences of the federal and provincial legislatures. I'm just wondering how you feel about that approach.
Well, you're referring to a school of thought or or an opinion, a view of things, if you want. And seeing as I'll repeat once again, seeing as I wish I would participate to such a debate which can be presented to the court eventually, I would prefer not to comment at this time.
Well, let me try a different topic. I do have another one I wanted to get to that I think is quite important. The Supreme Court Act dictates that leave to appeal a case from a lower court should be granted when the case, as the law says, raises an issue of public importance. What the law doesn't do is explain what's meant by an issue of public importance. So I'm wondering, given the fact that you, like all Supreme Court judges, are going to have to sit on one of these panels, what kind of criteria you would apply in trying to determine what cases can be given leave to appeal?
Well, I'm afraid I would give you the same answers, because I wish I could tell you more, but I can't, because eventually I would participate in those decisions, and by respect for my colleagues or future colleagues, I think it would be preferable not to comment at this time.
All right, thank you.
Thank you, Mr. Reid. Nice try on each of them. But, Philippe Thune, avez-vous des questions?
Any further questions, Philippe Thune? Thank you, Minister. I will not ask you a question about the tree of the Constitution. I liked what you had to say about leadership. You said that it was something you had to earn and it couldn't be imposed. I'd like to go back to a theme I raised earlier. That is, decisions that enable people to have confidence in our legal system. And I think that young lawyers it would be really good to ensure that these young lawyers get good training. And how do you see? I'll ask you a personal question. There are a lot of young lawyers, as you said, who get into the system when they get out of school, and they all want to work in international law. We often see that. So they take their international law course, and then they realize that it's not quite as romantic as they initially thought. How do you see the decisions and the deliberations of the court as playing a role to attract people to the legal profession? Do you feel that the Supreme Court has a role to play in attracting young people to the profession? Do you feel that the Supreme Court can have a role to play in training these young people? It's part and parcel of the essential role of a court. That is to render good decisions, to render decisions that are disseminated. And the issues today that are before the Supreme Court are always of national importance. So normally that should create some interest among young law students and lawyers. If the decisions are clear and have an impact on the future of Canadians, I would think that this would encourage young people to continue studying. Is that the angle you were trying to get at? In the court decisions, I go back to this idea that often the decisions are not unanimous. So one judge who gives a decision on behalf of others, well, this can lead to controversy. Do you feel that we should be making a distinction here? Do you think it would be more interesting for a student to look at a decision where there's a dissenting opinion, or do you think that it would be better to have another type of decision in the eyes of a student? What would be more interesting? A decision where there was general consensus amongst all the justices, or is it better to look at decisions where there are dissenting opinions and where you see the opinions of various judges? So I would have to ask that question of the students, but personally, there are some issues that do not lead to unanimous decisions. You referred to the majority decisions where there are also dissenting opinions, and you're asking whether or not is it a bit more interesting to have a decision where everyone's in agreement. First of all, it's always good to look at the divergences even within the majority. And secondly, perhaps there's no other way to get to a majority decision with all of these diverging opinions. But if you bear in mind, and regardless of your example, if you look at the will of judges to make decisions that are understandable, I don't think there should be any problem.
Mr. Justice Wagner, I believe I have the honor of coming last in this train of questioners, and I believe that you and the process have both done much to dignify our judicial system today and to explain it. And in that, I applaud you and thank you. As Canadians review this process and are with us today watching, many will express frustration over delays and inefficiencies in our system. And you touched on that in your introductory remarks. You referred to the inherent delays of a judicial process in that meeting that you attended in New York. The BC Commission on Justice Efficiencies recently issued a final report and expressed concerns on the criminal litigation side about inefficiencies and delays, and other provinces have also expressed that concern. Chief Justice Beverly McLaughlin has publicly expressed concerns, stating, and I'm quoting here, as delay increases, swift, predictable justice, which is the most powerful deterrent of crime, vanishes. I'm the member of New York Bar and the Law Society of England and Wales, as well as BC, and in the information I get, this is a truly transcendent problem in all Western legal systems. So I'm wondering if you might try to sum up some of your own concerns about inefficiencies and delays in our court system.
Yeah. Well, you know, it is, in my mind, this is the biggest challenge to our judicial system. Access to justice. And I don't think that the solution could be found by only one body or one person. I think it could be found by communication, by joint effort of many persons or entities involved in it. And access to justice, remember 20 years ago, or maybe even 15 years ago, you would see sometimes in certain cases, mostly in family law, you would see somebody representing himself or herself. These days, you will find before the trial division before the Court of Appeal, you will find people more and more who will represent themselves. And that's a reality which you did not have 20 years ago. And it brings all kinds of problems as well. So access to justice is legal aid also. People are too rich to benefit from legal aid, but they are too poor to pay for their own attorneys. It's the same everywhere. Delays, all kinds of problems. And all these problems cannot be solved by only one entity. It's a joint issue. I think that everybody should talk to each other, but it's very serious. But there are things that can be done, but it must be done collectively and in accordance with everybody. Well, I think there's some hope, because I'm sure that now the people are concerned with that and realize the importance of the issue.
Thank you. Thank you, Mr. Mayor.
Colleagues, that concludes our questioning. Maître Baudouin, some final words?
I do not want to lengthen this session unduly, but I'd like to thank you and thank all of the parliamentary colleagues for this dialogue, this exchange of ideas that we've had with Judge Wagner, and particularly for one reason. We've given the general public an opportunity to better understand the nomination process that for the average person is something that is quite mysterious. We've demystified it somewhat. And through this exchange that we've had with Judge Wagner, we now understand the role played by the Supreme Court, the importance of the nomination process for the Supreme Court, the magnitude of the job that lies ahead, and the transparency of the process.
Comments well said. I can't let the opportunity go by, as so many of you have done today, without thanking my university, University of Windsor, for the excellent legal education that I received years ago. Colleagues, this has been a very worthwhile process. Thank you for so many of you who have worked so long on this. I know that you have gone now almost a couple of months examining these files and interviewing people, and I hope you haven't found it too long a process, but I think all of us benefit from this, and I want to thank you and all those who are here today for your questions. This has been a great exercise, and to all those who have supported all of us around the table here today, my thanks, and to the interpreters and to everyone else who has made this possible, and to the clerk, thank you very much for that, and particularly to you, Justice Wagner. This process, I believe, is a very worthwhile one to gain some transparency, let Canadians get some familiarity with those who occupy such important positions as the Supreme Court. And I think I speak for everyone that you have made everyone here proud today with your testimony, and I thank you for that. And we all wish you the very best in the future.
Thank you very much.
you.